Welcome everyone to the Federal Bar Association Key sections, The Rounds, FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald, Programming Chair of the Key section, here with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott, Happy New Year.
Tejinder, Happy New Year to you. Let's start with Olhausen versus Arriva Medical in the 11th Circuit, a case that the Supreme Court accepted along with Schutte versus SuperValue, and then it remanded it back to the 11th Circuit for reconsideration in light of the 2023 decision in SuperValue, which of course clarified the FCA's scienter requirement. So now on remand, the panel at the 11th Circuit reverses its previous affirmation of a motion to dismiss. It's a procurement opinion to gender, and it barely mentions SuperValue. What did we learn here?
Yeah, so the way this case went, it was a weird procedural posture. Initially, the district court dismissed the case on Rule 9b grounds, which is something courts in the 11th Circuit do quite frequently, as that circuit has a pretty strict view of Rule 9b. So there was an appeal, and on appeal, the 11th Circuit affirmed on alternative grounds relating to scienter. And then SuperValue said, nope, don't do that. And so after the decision was vacated and remanded, the 11th Circuit said, okay, maybe we'll actually talk about the Rule 9b question that was before us the first time. And they reach a mixed decision in the case. They say the relator had pleaded with particularity that certain types of claims were presented, but not others. So as I alluded to a moment ago, the 11th Circuit has a relatively strict standard for saying that claims were presented. You either have to show the specific details of actual claims or something else really, really, really high. And here, the court holds that something else is satisfied because the relator was able to point to audit results inside the company based on his role as an insider that he was familiar with that really showed that they didn't have the legal prerequisites meant to make claims for about 47% of the claims that they were actually submitting, even though he wasn't able to identify specific individual claims that were submitted to the government. This was deemed to be enough. And this is actually probably close to a high watermark for the 11th Circuit on Rule 9b. That court tends to be quite strict in how it applies the rule. And so the mixed decision here is some positive news for relators, I think.
So let's look at another 9b case, this one out of the Second Circuit, US X-Rail Camburn versus Novartis. Here, the relator alleges violations of the anti-kickback statute as a predicate for certain FCA claims, and as a matter of first impression, the panel sets a fairly forgiving standard for how to plead such a violation. Tejinder, tell us a little bit about the case and the at least one purpose rule.
Yeah, this case is about speaker programs. So this is a common target in kickback cases. Pharmaceutical companies have these programs where doctors come and they give some speeches, but a lot of times the programs are a little bit shammy. You know, the talks are under-attended, people are served up in very lavish locations with meals and stuff like that. Kind of disproportionate to the importance of the actual speaking going on. And so the question that arises in these cases is, were people actually being brought in to distribute medical knowledge, or are they just really being, paid money for a sham speaker event? So Novartis here is the defendant, and the allegation from one of their salespeople is that's what they were doing. And the first question the court gets to is, how important does the idea of inducing referrals or inducing prescriptions have to be to the defendant's intent? Does it have to be their primary motivation when they offer a remuneration? Does it have to be the sole reason they offered it? Or is it okay if it's just one of their purposes? And the court says, consistent with the holdings of, I think, every other circuit that has considered the question, that one purpose is enough. So even if you had alternative motives, for giving the money to the doctors or inviting them to speak, it is enough if one purpose of the program was to induce them to prescribe more, induce referrals that would be reimbursed by the government, because that's enough to taint the medical judgment and activate the purposes of the anti-kickback statute.
So let's turn to two new opinions involving the False Claims Act's public disclosure bar, something that we have covered on a number of previous episodes, Tejinder. Let's first focus on U.S. ex-rel Stebbins versus Maraposa Surgical, where the Third Circuit panel affirms the district court's dismissal, where the district court calls the relator's action a classic parasitic lawsuit. What happened here?
Yeah, so this is a case where the defendant was providing arteriograms, imaging of the arteries, and the question, the alleged fraud was that this could only be provided in an ambulatory surgical center setting, but they were providing it in a medical office setting, and that was wrong. Now, it's unclear whether that was actually illegal in Pennsylvania where this happened, but the relator in this case was an outsider to the relevant company, which I think is why the district court called it a classic parasitic lawsuit. The dismissal on public disclosure grounds was based on the idea that the fact that they were providing these services in an office-based setting could be determined by looking up certain claims data that's publicly available under the National Provider Identification Number of the practice and the physician. And then the fact that they were not listed as an ambulatory surgical center was available if you looked at the Pennsylvania Department of Health's website. And so the courts here, the Third Circuit says, yeah, that's publicly disclosed, all the facts you basically need to know that they're providing these services in an office setting, which is the alleged fraud. You could determine from these two sources. The one thing that is kind of interesting about this, and the one that I think is like pretty wrong, is the court says the published information on from Medicare, that's a federal report. CMS published data as a federal report and therefore falls within the ambit of the public disclosure bar. And that's probably right. But the second part, it says the Pennsylvania Department of Health's website is the news media. And I cannot understand why courts think everything on the internet is the news media, but they do sometimes hold this. And there's disagreement about this at the district court level. And I think it will bubble up into circuit court disagreement soon. But I think that if you think about the plain meaning of the word news media, you wouldn't think of the Pennsylvania Department of Health's listing of who's an ambulatory surgical center as like the news. But here the point was actually conceded, and the district court and the circuit court proceeded on that basis. And so they said all the relevant facts are out there. We dismiss the case.
Let's turn to Omni Healthcare versus U.S. Oncology, Inc. in the Second Circuit. This is an unpublished summary order that affirms dismissal under the public disclosure bar. The ruling is interesting because the relator, a medical company, is forbidden from moving forward because it previously made related accusations in a False Claims Act case where it wasn't the first to file. The relator therefore doesn't qualify as an original source in the new case, the panel rules. Tell us what happened here, Tejinder.
Yeah, so I'll also disclose that I have actually advised this relator in a handful of cases from time to time. But this ruling on the public disclosure bar does two things that I think are pretty dramatic. The first is the one you pointed to. So the way this action went, the relator, Omni, filed an action in 2012. That action was dismissed under the first to file bar. So not a merits dismissal, but it was just tossed out on that reason. The claim was refiled in 2019 after that dismissal. And now the Second Circuit says, well, yeah, everything was publicly disclosed by your prior action in 2012. And so, you can't bring this action. And the relator argued, rightly in my view, like, look, the public disclosure bar is designed to stop the sort of parasitic relator who sees something out there in the newspaper or in the world and says, aha, I'll just bring a False Claims Act case. You can't be a parasite unto yourself, right? Like sucking your own blood doesn't do anything. And so how could this possibly be the case that this is that? But the court's unpersuaded. It says, look, the plain text of the statute has no carve out for this. So it doesn't really matter. Now, the way you would normally think that this would get fixed is under the original source exception. Because if you were the source of the information that was originally disclosed earlier, you could say, hey, I'm the original source. But the Second Circuit does something a little odd on the original source exception too. The original source exception has a requirement that you have to voluntarily have provided your information to the government before the relevant disclosure or before the relevant disclosure occurs or before your action is filed. And what the court says here is it says, nope, none of your prior disclosures to the government were voluntary because they were part of the False Claims Act's requirements that you disclose all your material evidence when you file your action. And even though there was a declaration that said, even before the action was filed, we had more meetings with the government to talk to them about the case and we showed them our evidence, the court says, nope, that's still all part of your mandatory disclosure. So I think that that is actually probably just wrong on the facts. That is, disclosures that occur before filing are not really part of the mandatory disclosure that has to occur contemporaneously with the filing. But more is the point, I think it's hard to understand what relators are really supposed to do under this rule to have a voluntary disclosure. I assume that what they need to do is something very formalistic, which is send a message that says, here's our voluntary disclosure, and then presumably send the same information again and say, here's our mandatory disclosure. I don't know what interest could possibly be served by that other than just like setting a trap for the unwary. But the Second Circuit definitely did that.
Tejinder, let's return to the case that made waves in late 2024 and certainly will be making waves in 2025. Zafirov versus Florida Medical Associates, now in the 11th Circuit, where the constitutionality of the FCA's qui tam provisions are very much in the crosshairs here. You're on the relators team, Tejinder, in the case, and you just filed an opening brief, as did the United States government, which has intervened to defend the constitutionality of the qui tam provisions of the False Claims Act. We'll talk about the Department of Justice's brief in just a moment, but let's first turn to your brief. It makes a number of arguments, but it really leans on the history of the False Claims Act. There are shout outs to Alexander Hamilton, John Adams, James Madison, and other founders. You argue that the constitutional provision of the False Claims Act is firmly rooted in history. Give us a sense, if you will, of the tack that you took in that brief and what arguments you made for the 11th Circuit.
Sure. I think that there are, broadly speaking, three categories of arguments made in the appellant's brief. The first is that every court that has considered the question, other than the district court in this case, has held that the qui tam provisions are constitutional under Article 2. And so there's a survey of that precedent and an explanation for why things the Supreme Court has said about the False Claims Act should compel the 11th Circuit to do the same. And most notably, there's a discussion of the Vermont Agency versus Stebbins decision from 2000, which says relators have Article 3 standing, and the reasons why the history reference there is also dispositive vis-a-vis Article 2. The second bucket of arguments is really explicating that history. In Stebbins, the court pointed to what it described as a considerable number of qui tam statutes enacted by the first Congress. I think it pointed to about 7 of them. In reality, there were dozens of qui tam statutes enacted by early Congresses, not just the first, but almost every Congress going forward enacted at least some of them. And they started getting repealed in the 1900s, the late 1800s, early 1900s. But prior to that, there were a bunch of them by early Congresses. And there's good Supreme Court precedent saying that when you have early Congresses consistently doing something, that's a very good sign that that thing is not unconstitutional. And tellingly, not a single qui tam statute has ever required the relators to be appointed pursuant to the procedures in the Appointments Clause, which is pretty good evidence that it's not required. The third bucket of arguments has to do with applying modern Appointments Clause doctrine. That precedent says that the difference between a government employee and a government officer is two things. First, the person has to occupy a continuing position in the government. And second, the person has to exercise significant authority pursuant to the laws of the United States. We argue that there's actually no employment to begin with, so this whole thing fails at the threshold But even if there were a position, it's not a continuing position because it only lasts for one case, doesn't come with any salary or title or position inside the government. And second, that there's not significant authority because qui tam plaintiffs are essentially private litigants. Their litigation has byproducts that are positive for the government, but they never actually exercise any government power, right? When you file a False Claims Act suit, no one gives you like a windbreaker and a gun and says, go and exercise our investigative authority. It's just a private lawsuit like any other lawsuit. In fact, you have less power than most other plaintiffs because the government has all these oversight functions where it can, for example, intervene and dismiss your case. Which it can't do in an antitrust case or a securities case or a case under the Anti-Terrorism Act, which also implicate weighty national interests. So those are the three kinds of arguments that are made, but there's a real emphasis on the historical point, which we think could be quite important to judges who think of themselves as originalists, who I think are also among the judges who are more likely to take seriously some of these unitary executive type arguments that the defendants have advanced.
Let's turn to the Department of Justice's brief. It relies more heavily on the control that the government exerts over qui tam relators really at every step, rejecting the notion that they act as unappointed and therefore legal officers of the United States. The DOJ seems to have dropped, Tejinder, any pretense that it doesn't endorse all non-dismissed and non-intervened FCA cases, which it now says don't proceed without the active government buy-in at the outset. I mean, as a relator side lawyer, I'm rather excited about that provision in the brief. It seems like it may be something that we can cite to in the future on the relator side. What do you think?
Yeah, so I think the part you're referring to is if you go to pages 8 and 9 of the government's brief, that's where it's mentioned in the summary of the argument, and then it happens again in the argument section. They respond to the district court's belief that qui tam relators can effectively hijack the enforcement priorities of the United States by filing actions that are about whatever the relator cares about and not what the government cares about. And what the government says is, look, in every qui tam case, this is what happens. It's filed under seal, and then we get the first look. And we have the right to intervene and take it over. We have the right to dismiss it if we want to, or we have the right to say, we're declining to intervene and we're not dismissing, so relator, you carry this forward. And they say this front-end review ensures that every qui tam action that proceeds out from under seal and into litigation is consistent with the government's enforcement priorities. Now, I don't know if I would say that that's tantamount to saying they're fully on board, all in with all of the declined cases, but I do think we can say that the government has indicated that it takes a hard look at every case that comes through the door, that it considers whether it wants to allow it to continue or dismiss it. And so it is fair to draw a negative inference from non-dismissal, to say the fact that the government has allowed the case to proceed into litigation at least establishes that it's consistent with federal priorities, doesn't conflict with federal policy or the interests of the United States. And so to the extent defendants try to raise arguments like that, saying, oh, allowing this case to go forward will destabilize such and such government program, I think those arguments can now be dismissed much more readily based on what the government has said in this brief.
Oral argument, Tejinder. When do you think that might occur?
I do not know. So far, only the opening briefs have been filed. We don't even really have the full briefing schedule. It's possible that defendants may seek extensions of time to file their briefs. It's possible that we and the government may seek extensions of time to file their reply briefs. And then it will be up to the 11th Circuit to schedule the oral argument, which that can be variable. If we hear oral argument this year, I think that would be awesome, but there's a chance we won't. And so this could take a little while before we have a decision.
Tejinder, thank you. And thanks to each of you for joining us for this edition of the Federal Bar Association qui tam sections, the Rounds FCA News with Tejinder Singh. We'll see you next time.